our law firm represents a lot of people who are charged with drug charges, whether it's possession or trafficking in narcotics. And the first thing clients want to understand and that we explain to them is how the court system works, the typical court process, the timelines. What are the steps, if we're going to resolve your case, for example, by pleading guilty or hopefully getting the charges withdrawn, actually, right up to whether we're heading to trial, okay? So let me start, first of all, with summary conviction charges, the court process. This kind of lesser drug charges, if I might put it that way. So what happens, let's take it hypothetical. I always like to start with hypotheticals. So you're charged today, the police charge you, they arrest you, and let's say they release you on bail, an officer in charge undertaking or a promise to appear. And they're typically, give or take, they're gonna give you a court date like about 3 to 6 weeks down the road, maybe rarely sooner, but sometimes a little after that. So you hire our law firm, and what are the steps? What's gonna happen? So aside from giving you initial legal advice and meetings with you, the first thing we're going to do is we're going to order the disclosure. That's all of the evidence, the police reports, witness statements, video statements, you name it. The Crown Attorney has to provide that to us. Now, the Crown Attorneys in the province, they were always striving to provide disclosure before the first court appearance. Sometimes they do and sometimes they don't. So don't worry about that. Obviously, we hope to receive that early on, but sometimes, particularly more complex cases, it doesn't arrive till well after even the first court appearance. So we're going to appear for the first court appearance for you. You're going to sign a document called a designation, an enhanced designation is what it's called. And what that means is we are your lawyers effectively. We file that with the court. We show up at the first court appearance for you. You don't have to even attend. And we just report to the Justice of the Peace that we're acting for you. And the matter automatically goes over for 12 weeks. That's what happens. They brought that in during COVID. I think they're going to keep it after COVID because it's working well. Now, what are we expected to do in that 12 weeks? Well, we're expected to complete as many steps on the file as possible to move your file along, whether you're pleading guilty, whether you're heading to trial, or some other resolution where hopefully the Crown's withdrawing your charge if it's a weak case. So let's say we get the disclosure after the first court appearance, and that's often happens that way. We're going to review all of that. We're going to analyze it in the office. That could take hours or days, depending on the complexity of the case. Sometimes you get thousands of pages of disclosure in wiretap cases, or it could be a simple marijuana drug possession. Well, that's illegal now, but other types of drugs that are still legal. By the way, marijuana trafficking is still illegal. So we're going to analyze it. We're going to look at the viability of whether it's defendable. What do we think the Crown's going to offer? What do you think we can negotiate? I'm going to give you legal advice. There's going to be one or more meetings. You're going to review the disclosure on your own as well, provide a statement, and ultimately I'm providing you with a fulsome legal opinion about what your options are and what I think can be done with this file. I'm going to give you your odds of winning within a range. Maybe they're very good, maybe they're pretty good, maybe they're 50-50, or look, it's a very strong Crown case and we think you should resolve this. So with that in mind, and as per your instructions, I'm going to then meet with the Crown. It's called a Crown pretrial. That again is a fulsome discussion about all aspects of the file. I'm going to find out from the Crown what they're looking for in the case. In a perfect world, they're looking to withdraw the charge, or can it be diverted because it's a minor charge and avoid a record? Are they looking for conditional discharge? Those are pretty good offers if they've got a good case against you, because we're avoiding criminal records. Or are we heading to trial because the Crown's not playing ball? They're asking for too long a sentence, and we've got a decent chance to win. If it's a trial, the Crown and I are to discuss all aspects of managing court time, what the legal issues are, what applications are being brought by defense counsel or by the Crown, how long court time is going to take, witnesses are going to be called, you name it. Every aspect of what's going to happen in the trial is being discussed so we can effectively manage court time. That's very important in our province to preserve court time, and the courts expect us to give proper estimates. So I take that back to you. I get the Crown's position, I take it back to you. and hopefully I say they're withdrawing the charge. Great deal. We can bring the matter forward from the 12 weeks and get it withdrawn. Or they're offering conditional discharge. It's a strong case against you, avoiding records. Great, let's do that. I might need a judicial pretrial to get approval from that. Depending on the case, I might not. So don't worry about the 12-week timeline. Matters can always be dealt with, brought forward. The real steps in these criminal files, in a drug file, any criminal file, takes place between the court appearances. The court appearances, and I give a critique of this, it's really useless, these court appearances, to be honest with you. It's just a reporting mechanism. We're just showing up in court, the Crown and I, telling the JP the Justice of the Peace, what's going on in the file, and it's put over for another court date to complete those steps. And all the real steps, the meetings with the Crown, meetings with judges, meetings with you, my work in the file doesn't take place in court, it takes place out of court. So, if you're resolving it, we can do that fairly early on. Timelines for that may be, even shortly after the first appearance, we may be able to plead guilty if you want to take that route. That could take place in the 1 to 5 month range after the first appearance. On the other hand, you may decide to go to trial because the Crown's not offering any deal and we got a decent chance of winning. After I have the Crown pretrials, the next step I have to do is have a judicial pretrial, one or more of those. Usually we do it with one if it's a minor charge, lesser charge. Again, it's a fulsome discussion between the Crown, myself, and a judge about trial management issues. We're trying to estimate court time. I get to know the witnesses who are being called. How many witnesses am I calling? Am I bringing applications? All with a view to each person, the Crown and I, and the judge understanding what's going to happen in the trial and what's a proper estimate of trial time. So assuming we're able to keep that in one judicial pretrial, it might take 2, it might take 3, depending on the case. Now we're in a position to set a trial date for you. So how many weeks are we in? Well, it's probably unlikely that we've completed a judicial pretrial before the 12 weeks up is on your second appearance. It's probably going to take place after that. That 12 weeks may even have to go, well, that will have to go over. But hopefully we're in a position to set a trial date by your second or third court appearance for a minor case. How many months in are we right now? Well, we might be up to 5 months in, we might be 4, in some cases even 6, depending on the case. By the way, sometimes there's missing disclosure, which we're trying to get, and we can't set a trial date till we get that. There's often missing disclosure, which I have to write the Crown about. They haven't provided certain evidence that they should, because they haven't received it from the police as yet. So when is the trial date going to be set? That's always a vexing issue. It really depends on the county. Every county in the province is different. Some are very busy. You take Toronto, you take Brampton, they've got a lot of delays in their court system and trials get set way down the road. I mean, all the courts are booked every day. So you might not get a trial date in those type of counties and busy counties for, up to 15 months even after your first court appearance or your date of arrest, and sometimes even 18. By the way, if it's pushing past 18, you might have a delay application under Section 11B, which I covered in another video, but usually they get it set in lesser time. In less busy counties, smaller counties, Owen Sound, Walkerton, little counties like this, St. Thomas, you might get a trial date. I guess real ambitious would be to say 6 to 7 months after the first appearance, but in a perfect world, yes, but more likely maybe 9, I suppose. What's the average in the province? I would say in the 12 to 15 range from the first court date. It's hard to get quicker than that unless you're in a smaller county, but it does happen. Sometimes trial courts open up. So that's the trial, and I cover trials in another video. You can look at the trial process, you can look at how lawyers prepare for trial, how we prepare you. There's all these topics are covered. By the way, all of these little subtopics are covered: judicial pretrials, Crown pretrials, first appearances, designations. I cover these in all other videos in detail, and I encourage you to watch those. And again, in terms of your matter resolving, that can be done fairly early. It may or may not require a judicial pretrial to have a judge approve the deal. Sometimes we don't need approval, sometimes in my discretion I want to on a tricky case where it's a real good joint submission and we want to make sure the judge is on board. So that can be done fairly early. So that's kind of the trial process for and resolution process for a more minor charge where it's being tried in the Ontario Court of Justice. But what happens with an indictable charge like trafficking, where the maximum sentence, unfortunately, is life in prison? This affords you more rights in terms of your election. You can elect Ontario Court of Justice, judge alone trial. You can elect a jury trial in the higher court, the Superior Court of Justice, or a judge alone trial, the Superior Court of Justice. And also, you're entitled to a preliminary hearing because it's an over 14-year sentence. So if there's a preliminary hearing, you elect preliminary hearing, you elect Superior Court with a preliminary hearing. That preliminary hearing takes place in the Ontario Court of Justice. That's going to be the same timeline I just told you. You know, the 6 to 18 months, depending on the county, 6 to 15 months type thing, depending on the county. That's an evidentiary hearing. Again, I covered that in another video. I encourage you to watch it. After the preliminary hearing, assuming you're committed to trial, there was enough evidence to go to trial, your case then moves to the Superior Court of Justice. Well, we're already, 9 to 15 to even 18 months in. We're in the Superior Court of Justice. That matter's going to get, we have to have another judicial pretrial there. That's in assignment court. It's called assignment court. It's similar to Ontario Court of Justice, a remand court or a case management court. Again, there might be a series of a few remands. We have a judicial pretrial. Your matter gets set to trial. When all is said and done, particularly on a jury trial, it might be close to 36 months that we have your trial, maybe less, a bit. Again, the time limitation for Superior Court is supposed to be 36 months. If it goes beyond that, you might have a delay application. But the time takes much longer for Superior Court. But in many cases, it's beneficial to have a preliminary hearing. In some cases, not. Every case is different. So those are kind of the basic timelines for a less complicated drug case and a more complicated drug case. But the message I want to give you, timelines really depend on the individual counties as well. Some are less busy than others. But we can manage your time. We can bring matters forward to deal with. So don't worry that it's taking long in the remand system if you want to plead guilty. Some people are in a rush to plead guilty, by the way, or a withdrawal could be brought forward. So that the fact that it goes over in a 12-week increment and then goes over another 2 months, don't worry about that if you actually want to resolve your charge. So that's the typical process and timelines for a drug charge in our Ontario court system. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.